Welcome to CivilNet. My guest today is Levon Gevorgyan. He is a lawyer who represents Gurgen Margaryan's family. Lieutenant Gurgen Margaryan was an officer in the Armenia's army. He was murdered by Ramil Safarov during a NATO training. Thank you, Mr. Gevorgyan, for joining us.
Thanks for having me.
First, let me re-explain the criminal case that took place. So it was in 2004. An Azerbaijani army officer murdered Lieutenant Gurgen Margaryan in his sleep with an axe. They were both attending a NATO training in Hungary, in Budapest. Following the murder, Hungary sentenced Safarov to life prison, but after 2012, after an agreement between Hungary and Azerbaijan, Ramil Safarov was extradited to Azerbaijan to continue his sentence. However, once in Azerbaijan, he was pardoned and he was welcomed as a hero in his country. Following his pardon, Margaryan's family and yourself went to the European Court of Human Rights. What was the decision that was made on May 26th? And what was the final decision, and what do you think of this decision?
Well, again, thanks for having me. The issues raised before the European Court of Human Rights, not only by me, but by the group of representatives, because it was a large group of experts working on the project, there were primarily three issues. First of all, we claimed that there was a violation of the material limb of the right to life. I will translate that into English later. Then there was a claim that there was a violation of the procedural limb of the right to life. And of course, finally, we claimed that there was a violation of Article 14, which is the prohibition of discrimination under the European Convention on Human Rights. Now, let me explain what those legal terms like material limb, procedural limb, how they translate into common English. So basically, when we're talking about the procedural limb of the right to life, basically mean that the states are supposed to implement punishment, to investigate and to implement punishment upon all those individuals who are involved in the killings, murder, violation of the right to life. So whenever a state fails to prosecute an individual, whenever a state fails to implement a proper punishment, whenever a state fails to implement a punishment which is proportional to the severity of the crime committed, the state itself violates the procedural limb of the right to life. When we're saying that we claimed that there was also a breach of material limb of the right to life, we're basically saying that the killing itself, the murder, was attributable to the state. Now, here we need to clarify a bit what we understand under the term attribution under international law. Well, the primary rule is that the state is responsible for the acts of its state officials, which is plain and simple. But there can be situations where state officials act in their private capacity, or there can be situations where private individuals act in private capacity, but the state acts in such a way as to accept and adopt and acknowledge the acts as its own. So the primary claim here, one of the primary claims here, was that Azerbaijan, by pardoning Ramil Safarov, by glorifying his actions, by paying him retroactively the salary for the period when he was in prison in Hungary, basically adopted and acknowledged the acts of Ramil Safarov as its own. And that was our second argument. And finally, we claim that there was a breach of Article 14, which is the prohibition of discrimination, and that is that the pardoning itself and the further glorification that took place was primarily associated with the ethnicity of the victim of Ramil Safarov, with the ethnicity of Gurgen Margaryan and his Armenian origin. The court found breaches under at least two of our claims, which is the procedural limb, the disproportionality of the punishment imposed, and discrimination. And we'll talk about it after you raise the next questions, but this is primarily, essentially the first case by any international court or any international tribunal which confirms the fact of institutionalized discrimination in the state of Azerbaijan.
So obviously the third point was not in your favor. So the question that comes to my mind is, was that decision what you had expected?
That's a good point. That's a good question. Well, first of all, let's understand what was our plan minimum and what was our plan maximum. The plan minimum was that the court finds Azerbaijan to be in breach of procedural limb of the right to life, and that was in our favor. Plan maximum was our expectation was that the court finds that Azerbaijan is in breach of Article 14, and that is the prohibition of discrimination. When we're talking about the breach of the material limb, which is the attribution of the acts to Azerbaijan, we need to understand that this claim was to a certain extent experimental, or let's say novelist to a certain extent, because the European Court of Human Rights has no previous practice, has no previous case law of attribution of acts of private individuals or state individuals acting in their private capacity to states based on post factum adoption and acknowledgement. There's a certain practice by other international courts and other international tribunals, the most famous being the case by the International Court of Justice pertaining to the hostage-taking in Tehran during the Iranian Revolution. The case pertained to the mob of students which captured the U.S. embassy. Those were private individuals acting under private capacity, but the International Court of Justice declared that by, first of all, not preventing the actions of those students, not preventing the actions of the mob, and further condoning those actions, the Iranian state actually adopted and acknowledged the acts of those students as its own. And this was our, let's say, the basic case that we referred to when arguing the attribution of the acts to Ramil Safarov to the state of Azerbaijan. Of course, this point was not in our favor, but we see significant grounds for escalating the issue before the Grand Chamber of the European Court of Human Rights. At least one of the judges, in his dissenting opinion, Judge Albuquerque, made a dissenting opinion in our favor and referred to the predominant case law by other international courts and tribunals and agreed with our position. So yeah, there is still, though this point was not in our favor, we did not consider this as a loss. We consider this pretty much as an opportunity to go forward.
We'll come back to Mr. Albuquerque.
Yeah.
So before this, let's talk about Philip Leach. So he's the director of the European Human Rights Advocacy Center. And he said about this case that the case covered actually new legal territory, and the court ruling could have profound consequences for future cases of prisoners' transfer. According to you, would the Margaryan case change anything in the future?
Yeah, absolutely. Well, first of all, Philip Leach was one of the representatives of the family. He was the international expert involved in the process. Of course, as I said, there are at least a few novelist elements in this judgment. The pardoning element, the European Court of Human Rights did previously address the issue of pardon and transfer in its judgments, but this is pretty new in the terms of its severity. The court's judgment is pretty new in the level of its elaboration of the legal principles, and of course, as I said, the element of attribution, which is still pending, of course, subject to the agreement of the applicants and their relatives of Gurgen Margaryan and Paitjan, which is the other applicant in the case, but there is a possibility for the European Court of Human Rights to elaborate further on this matter as well.
And why is this decision actually so significant for Armenia?
Again, as I said, this is pretty much the first judgment by any international tribunal which establishes the institutionalized policy of racial discrimination in the state of Azerbaijan. It may have significant ramifications, not only at the level of the applicants and at the level of restoration of their rights, but also at the level of the interstate negotiations, and why not also in terms of the Nagorno-Karabakh dispute. Because there is a significant issue of this matter or this judgment and judgments similar to this, and we hope that there will be other judgments pertaining to the April War, etc., which establish the fact of institutionalized discrimination, are a significant tool in the hands of policymakers and diplomats, because it raises major questions as to how would someone see a peaceful coexistence of Armenians, potential coexistence or theoretical coexistence of Armenians within the boundaries of a state where a murder of an Armenian is an act worthy of glorification, where a murder of an Armenian is a shortcut to getting bonus package from the government and an apartment. So again, as I said, this issue is now primarily in the hands of the diplomats and foreign policymakers, and as to how they are going to utilize to the utmost benefit of Armenia, and why not also Nagorno-Karabakh.
So let's talk more about the role played by Hungary here. So the agreement between Azerbaijan and Hungary when they extradited Ramil Safarov was a financial agreement. In this case, so the judges did not give any decision where it put blame in some way on Hungary. However, as we said, the European Court, one of the European Court judges, Paolo Albuquerque, commented on the ECHR's decision, saying that Hungary was aware of the likelihood of that Safarov would be granted a pardon. Does the decision reduce for you or remove Hungary's responsibility in this case?
Well, unfortunately, the European Court of Human Rights pretty much turned a blind eye on the circumstances that were happening alongside the transfer. Primarily purchased by Azerbaijan of Eurobonds issued by the state of Hungary, the amount of investments made by Azerbaijan into the Hungarian economy, the visit by high-level Hungarian authorities to Baku, etc., etc. So the European Court of Human Rights pretty much tried to assess the matter only in the context of the communication that happened between the two states and pertained to the transfer only. This is, to a certain extent, deplorable, but at the same time, Hungary definitely was not our primary target during the proceedings, during the litigation. We would hope that the Grand Chamber, during its elaboration and assessment of the situation, if it comes to Grand Chamber, tries to assess the situation in its whole context and does not touch only upon the formalistic side of the whole process and the documents and the letters and the wording which was used in those letters, but looks at the broader picture. At the same time, if we're talking about the formalistic part, which is the documentation and the diplomatic communication that took place between the two states during the transfer, our firm belief is that in itself, this documentation and communication was not enough for Hungary to be confident that Azerbaijan was not going to grant a pardon to Ramil Safarov. Well, first of all, the assurances granted to the state of Azerbaijan were not to the state of Hungary, were not at a sufficient high level. The assurances were granted at a level of Deputy Minister of Justice. The assurances were in the form of informing Hungary about the legislation that is in place in Azerbaijan. So Azerbaijan did nothing more than just inform Hungary about what legal proceedings and what legal framework exists in the state of Azerbaijan without providing any significant guarantees. So again, this is one of the issues that we think can be chased further before the Grand Chamber, but this is not a significant matter because the significant points are already in our hands, pretty much, which is the breach of procedural limb and racial discrimination, ethnic discrimination in the state of Azerbaijan.
How ECHR's decision can be implemented, knowing that, given the fact that there were previous such cases also that remained unimplemented, be in Azerbaijan or Armenia?
Well, again, here we move basically from the courtroom to the halls of diplomatic negotiations. And let me explain why it's like that. The European Court of Human Rights did not impose any monetary compensation or pecuniary damage on the state of Azerbaijan, and for the sole reason that the applicants did not claim any such compensation. The firm position of the applicants was that the life of their relative cannot be assessed in any monetary form, and their primary goal here was to seek justice. The European Court of Human Rights did not clarify which are the specific steps that are expected of the state of Azerbaijan to remedy the situation and to restore the violated rights. Under public international law, there are basically three forms of restoration of breaches of international rules of international law. First of all, restoration of the state that existed prior to the violation. We understand it's impossible in this case. Compensation or some other form of retribution for the restoration of the initial situation, and satisfaction, which is more of a moral contribution. Now, when we're talking about restoration of justice in this specific situation, we need to understand that, of course, the primary goal, the primary purpose which was sought by the relatives is to see Ramil Safarov in prison. Now, we have the European Court of Human Rights stating that there are two violations here. A violation of the procedural limb, that is, the punishment was not proportional. Violation of the prohibition of discrimination. How these violations are going to be restored, or how Azerbaijan is going to implement the judgment of the European Court of Human Rights, is something that is going to be assessed in the Committee of Ministers of the Council of Europe. So ministers, foreign affairs, gather within the forum of the Committee of Ministers from time to time to discuss the implementation of judgments of the European Court of Human Rights. So it is incumbent on the representatives of our Ministry of Foreign Affairs to raise the issue permanently and frequently before the Committee of Ministers about how Azerbaijan has been in charge of implementation of the findings of the European Court of Human Rights. Azerbaijan is, of course, going to come up with certain justifications, certain actions, which, in their opinion, could be considered as proper implementation or not. And it is incumbent on our Ministry of Foreign Affairs to challenge those. If the process prolongs for a certain period of time, there is a procedural possibility for the issue to come back to the European Court of Human Rights to clarify the form and format of the expected action, of the action expected of Azerbaijan for the restoration of rights. So that is what is going to happen.
And do you plan to make some further step in that sense for yourself, or do you plan to work with the claimants yet still? And how would you plan to work with them? What is the next step you do?
The next step, of course, is to understand the intentions of the applicants and to see whether they are seeing a prospect or are willing to use the prospect of raising the issue before the Grand Chamber, that is on attribution and as well as violation by the state of Hungary. And then, of course, we're going to monitor closely the situation in Azerbaijan and how Azerbaijan is allegedly implementing the findings of the court. And if the findings of the court are not properly implemented, we're going to take further action.
Thank you for this talk.
Thank you for having me.
Thank you for watching, and continue to follow CivilNet.